Okay, we're going to go ahead and get started. Good morning for everybody on the West Coast and good afternoon for everybody else. Welcome to our webinar on the current state of IP, brought to you by the Lathrop GPM IP team. I am Erica Van Loon. I am a partner at Lathrop GPM in the Los Angeles office, and I am the practice group leader of the intellectual property litigation team. My personal practice comprises copyright, trademark, and patent litigation at both the district court level and appellate court level nationwide. Now I would like to introduce our wonderful panelists today. I'll start with Amy Brosnick. Amy is a partner in our Overland Park office in Kansas. She specializes in trademark prosecution and international portfolio work and licensing. And I asked all of our panelists, just for fun, to let me know the first place they would like to visit when it's finally safe to do so. And so Amy let me know that 1 year ago today, she was actually vacationing along the Dalmatian coast of Croatia, and she is looking forward to getting back there soon. That sounds so lovely. Welcome, Amy. Next, we have Eric. Excellent. Next, we have Eric Sidler. Eric is coming to us from our Kansas City office. He works on an array of complex patent and trademark litigation matters in federal courts nationwide. Eric is looking forward to traveling to both France and Italy when it is safe again to do so. Welcome, Eric. Next, we have Molly Littman. Molly is an associate in our Minneapolis office. Her practice comprises IP litigation and business litigation matters. Molly is looking forward to traveling to Italy's Amalfi Coast when it is safe again to do so. Welcome, Molly. And for the record, I personally am looking forward to taking a photo safari to Africa with my family that we put on hold due to the coronavirus. So just a few housekeeping matters before we begin. We want to make this webinar as interactive as possible for everybody. You'll notice at the bottom of your screen, there is a chat feature. If you have any questions at any time that you want to ask one of the panelists, go ahead and submit your questions through the chat feature, and we'll try to get to as many of those as we can today. Also, I wanted to let you know that the webinar is being recorded, and it should be available on our website by Friday, along with a copy of the slides. You will receive a follow-up email from our firm directing you to that page on your website, and also follow-up information will be sent to you regarding CLE credit for Missouri, Kansas, Minnesota, and California. All right, let's go ahead and dive right in. We're going to first take a look at what's going on in the federal courts. So Eric, I'd like to start with you. Could you please give us an overview of what is going on in the federal courts right now with respect to IP litigation?
Thank you, Erica. Hi, everyone. Eric Sidler from Lathrop GPM in the Kansas City office. Thank you for joining us today. Well, the federal courts are open for business. Cases are still being filed. And I'd like to look at a few trends through analysis of some case filing statistics taken from Lex Machina as of June 1st of this year. As part of this, we're going to do a series of interactive polls. So I hope you're ready to answer a few questions. We could turn to the first question, please. First question is, are courts more busy, less busy, or as busy in 2020 with patent litigation as compared to 2019? I'll give you a few seconds to input your response, and we'll see what everyone's opinions are. All right, let's see the results. All right, 43% said more busy. You are correct. The correct answer is more busy. As of June 1st of this year, there were about, and this is patent litigation specifically, there were about 150 more pending patent cases than there were as of June 1st, 2019. So patent litigation has actually increased over 2019. In addition, patent cases are being filed at a faster rate than they were in 2019. Through the first 5 months of 2020, about 130 more patent cases have been filed than were filed during the first 5 months of 2019. All right, next question. What is the busiest venue right now for patent litigation? Again, I'll give you a few seconds. All right, let's see the results. "35% said the District of Delaware." Again, we've got a smart group here today. You guys are correct. Just a little bit less than that, 31% said the Eastern District of Texas. That's a reasonable choice, but the correct answer is the District of Delaware. As of June 1st, 2020, the District of Delaware had nearly a quarter of all pending patent cases, 23%. In a distant second was the Eastern District of Texas at 11%, followed by the Western District of Texas at 10%, the Northern District of California at 9%, and the Central District of California at 6%. And for our third question, what is the fastest growing venue right now for patent litigation? I'll give you a few seconds. You can see the responses. All right, 3 out of 3. You guys are on top of things. The Western District of Texas at 41% is the correct answer. In the last year in particular, the Western District of Texas has emerged as a patent litigation hotbed. It now has the third most patent cases of any venue at 10%. A year ago, the Western District of Texas didn't even break the top 6. So far this year, nearly 1/5 of all new patent cases, 19%, have been filed in the Western District of Texas, putting it on par with the District of Delaware in terms of new filings. So why is this? There are 2 primary reasons that we can discern. Number 1 is Judge Alan Albright, District Judge of the Western District of Texas. Judge Albright is a former federal magistrate with decades of experience as an IP litigator, and particularly in patent litigation. He became a district judge in September of 2018 and has been vocal about his desire for the Western District of Texas to become a patent litigation hotbed. And so far, he's succeeded in persuading litigants to file. Recently, he became the judge with the most active patent cases of any other judge, surpassing Judge Rodney Gilstrap of the Eastern District of Texas and Judge Leonard Stark of the District of Delaware. And so far this year, Judge Albright is presiding over 16% of all new patent cases filed, which is, I believe, 10% more than his closest competitor, Judge Gilstrap. Number 2, the second reason for this trend is no doubt the 2017 decision in TC Heartland versus Kraft Foods by the Supreme Court. In that decision, the Supreme Court narrowed proper venue for patent disputes to venues where the defendant is incorporated or has an established place of business. Previously, defendants could be sued basically anywhere that they made sales. As a result of that decision, the Western District of Texas has emerged as a more favorable patent venue at the expense of, for example, the Eastern District of Texas. Unlike the Eastern District of Texas, the Western District includes several major metropolitan areas that call many companies home, including Austin with its tech companies, as well as Waco, El Paso, and San Antonio. Next slide, please. Although courts remain open and litigants are continuing to file suit in patent cases, clients need to expect delays right now due to the COVID-19 pandemic. Filings are up as compared to 2019 slightly. However, case activity is generally slower as courts have been impacted in their ability to handle normal litigation loads, and parties and counsel as well have been impacted. So far, trials sent through at this point at least June 2020 have been continued. There are exceptions that are continuing trials scheduled out into it as late as August or September. The Northern District of Illinois has continued trials scheduled through August 3rd. The Northern District of California has continued trials scheduled through September 30th. For obvious reasons, this has caused a dramatic downturn, drop off in the number of patent trials so far this year, a nearly 50% drop off as compared to 2019. Other case deadlines, however, have remained unaffected generally, absent an extension agreed upon by the parties. There are exceptions. One is the Northern District of Illinois, which has granted blanket extensions of all case deadlines. Nevertheless, cases in every jurisdiction have been delayed considerably as parties and attorneys are restricted in their ability to travel, and clients have experienced severe business disruptions as a result of the pandemic. Next slide, please. So what can clients do to move things forward in the current environment? Number one is alternative dispute resolution, for example, mediation. Many courts are encouraging these sorts of alternative dispute mechanisms to be conducted remotely through video. And we have done mediations via video for clients. Also, many depositions are being scheduled and conducted remotely through video, and as well as hearings, both through video and telephonic means. Most courts have embraced these sorts of technologies, particularly for motion hearings. An example is Judge Alan Albright of the Western District of Texas, who I mentioned earlier. He's kept all hearings on schedule and has conducted them telephonically. He allows parties to email him before the hearing with any PowerPoint slides they want to refer to during the hearing. And this includes Markman hearings. Other judges and venues have adopted similar practices in light of the pandemic. And as you'll hear a little bit later on in this presentation, even the Supreme Court has begun wading into telephonic oral argument. As far as trials conducted via video, while some state courts have been conducting trials via video feed, to date we're not aware of any federal court doing so, at least in a patent case or any other type of intellectual property case. However, I would note that the Northern District of California, in one of its recent standing orders, is allowing individual judges in that forum to offer bench trials in lieu of postponement, to offer those remotely. This obviously presents unique challenges for both attorneys, witnesses, and jurors, as well as judges. It may not be feasible on a large scale, given disparities in access to high-speed internet, given cybersecurity concerns, given constitutional concerns as well. Ultimately, in light of the current pandemic, we want to emphasize it's important for patent holders and other intellectual property right holders to be vigilant in enforcing their rights. Cases may take longer to resolve as a result of the pandemic, but IP rights holders, ignore infringers at their peril.
Thank you so much, Eric. Amy, let's turn to you for a moment and talk a little bit about what's going on right now at the U.S. Patent and Trademark Office and the U.S. Copyright Office. Are there any specific provisions of the COVID-19 CARES Act that we should be aware of?
Yeah, thanks, Erica. There are certain provisions of the CARES Act that have affected timelines for filing responsive documents or payment of fees at the USPTO. And so certain dates have been important. Basically, from the time the CARES Act was signed on March 27th up through May 31st, if there was a filing that was due or a fee payment that was required, but the stakeholder was unable to make that payment or filing within that time period due to the coronavirus, they were granted a blanket extension up through June 1st. Obviously, that date was a few days ago, and so the USPTO last week put out a new alert stating that, well, they weren't going to extend a full blanket extension to a date in the future, that they would consider a request for relief on a case-by-case basis. So the items I'm going to discuss now are still available for intellectual property owners, but more on a case-by-case basis. So essentially, if your filing was due during that time period, you could request relief from basically having your trademark abandoned or canceled by submitting a statement indicating that your delay in meeting that requirement was materially due to the COVID-19 outbreak. So that word materially is important because the USPTO is looking for information that, whether this is due to the practitioner, the trademark owner, or anyone associated with the filing, if you were materially impacted, whether that meant your office was closed and you were unable to gather responsive documents, or perhaps you had cash flow interruptions, or even if you or one of your family members was affected by the illness, those are some examples of reasons why the USPTO would grant relief from having to meet that earlier deadline. Now, it's important to note that you still are required to provide whatever responsive information was necessary to meet that requirement, and also to pay any regular fee that was due during that time. But petition fees or petitions to the director, that particular fee was going to be waived as a result of the late filing. So in terms of trademark filings, what types of things were impacted during the time period? That would be something like a response to office action, statements of use or extensions of time. If you have a registration, a declaration of use, or an application for renewal could meet that relief requirement. And looking at the Trademark Trial and Appeal Board, if there was a third-party mark that you wanted to extend the opposition period or file an actual notice of opposition, those types of filings are eligible. So we could advance to the next slide. We'll dig in a little bit more about the Trademark Trial and Appeal Board proceedings. So the USPTO notice didn't go into further detail about any other requirements or any specific deadlines, but certainly things like trial deadlines, motion deadlines, those were certainly subject to extensions or suspensions. Generally, the parties are very liberal in granting those types of extensions. So that's obviously one of your first go-tos, is to contact opposing counsel and discuss a reasonably extended time period for any opposition or cancellation. But if you're in the situation where opposing counsel wouldn't agree to that, then the board may be willing to grant a unilateral motion to extend or suspend certain deadlines. Also on the patent side of the house, there are similar relief options available during that time period, such as, again, responding to office actions, payment of issue fees, or other maintenance fees. PTAB proceedings also, we're seeing extensions, whether agreed to by the parties or having to unilaterally seek one. And also, interestingly, there's a pilot program going on at the USPTO for any patent applications, certain patent applications that may have an effect on combating the COVID-19 virus. There's specific requirements. Basically, small and micro entities may be able to request an expedited examination of the patent application if any claims or processes dealt with the COVID-19 pandemic, and if they were also subject to FDA approval. So for any patent holders that are feverishly working on inventions that may help us combat the virus, there may be some expedited things available to get those examined. We'll move on to the next slide, please. And I just want to spend a minute looking at more closely some trademark issues related to filings that are due at the USPTO. Obviously, trademark rights are tied to use in commerce, and there have been many businesses that have been interrupted or sidelined during the past few months. And so, particularly if you're facing a deadline where a declaration of use is required, and perhaps you have a business like a restaurant or a hair salon that you're unable to function in a virtual world, what options might be available for you in terms of not being in a position to provide proof of use during this time? So if you're looking at a registered mark, first you could see if there's a grace period available. So as you know, the the regular statutory deadlines for declarations of use, either between the 5th and 6th year after registration or at the 10th year anniversary of registration, automatically get a 6-month grace period. There's nothing you need to do to file to request that additional time. It's just automatically granted. So take a look at your calendar and see if you do have that opportunity for that additional 6 months. And if not, if you're in that grace period and you're facing the deadline of how do I show proof of use when I'm unable to at this point, there is something called a declaration of excusable non-use that's available. And seemingly the COVID-19 situation would be a situation where there may be excusable non-use that's available. Traditionally, excusable non-use was available if circumstances were outside of the trademark owner's control. And so obviously a lot of us are in that situation where use in commerce may be completely outside of the owner's control. So that's something that can be looked at. Now, if you have a pending application and you have a statement of use deadline, as you may know, there are up to 5 extensions available to give you 36 months after the notice of allowance is issued to prove use. And so if you're in your first couple of extension periods, go ahead and take that extra extension. Let's say you're up at your very last extension. The latest USPTO communication on the CARES Act did include a provision where petitions to the director could be made if you were in that situation of being unable to prove use at your very last statement of use extension. So that may be available. And obviously, one of our go-tos for applicants in that situation was to simply go ahead and file a new intent to use application. So that could be an option as well. So before we move away from the USPTO, my fun poll question is, can anyone tell me who the current director of the USPTO is and what is his or her correct title? So we have a few multiple choice questions up if you want to take a look and submit your response. Give everyone a second or two and see if everyone's up to date on who the head is of the agency. All right, 56% got the correct answer, Andre Iancu, and his correct full title is Undersecretary of Commerce for Intellectual Property and Director of the USPTO. So great job for those of you that selected his name. Now I will say that the other names are correct, past directors of the USPTO, but the titles were a bit jumbled and obviously they're not the current ones. So thanks for participating there. And we'll just move quickly to mention a couple of things going on at the Copyright Office as well. So the Copyright Office is housed in the Library of Congress, and in normal times you could go in and tour the building. It's a really beautiful structure there in Washington, D.C., but it has been completely shut down, obviously. And so all of the copyright examiners have been removed to a remote location to continue examining. But as anyone who's filed anything with the Copyright Office knows, their technology aptitude may be a bit lagging some other federal agencies. So a few things that they have done to try to address the current situation is to expand capabilities of what types of filings are available electronically. In the past, they had made a lot of effort to make nearly every type of registration application available electronically. So most of those are quite relevant, but a few other types of submissions, things like requests for reconsideration when responding to a refusal, those were traditionally only available to be filed on paper, and now they are accepting those electronically. Other things like notices of termination and other types of licensing submissions are able to be filed electronically now. And then, certain physical deposit copy requirements have been lax a bit. Certain things like textiles is something that you were required to submit a physical copy. For works in CDs, DVDs, or film, the Copyright Office required the the best edition, and generally we would submit a physical copy. Well, now they're allowing you to upload an electronic copy with your application, and that will get examined faster, but you're still required to submit the actual physical copy as well and just sign a declaration that those are identical. So at least that's been speeding up examination there, and particularly in special handling requests and things like that, you'll want to be able to get the information to the Copyright Office as expeditiously as possible. So those types of options have really been helpful. I think that's all I have for those two government agencies right now.
Thank you very much, Amy. So let's talk a little bit about what's been going on at the U.S. Supreme Court. There have been several Supreme Court decisions in the last term that have dealt with IP issues. So Molly, let's talk a little bit about some of those decisions, starting with the Booking.com decision.
Yeah, Erica. So USPTO versus Booking.com was recently argued before the U.S. Supreme Court in the first telephonic hearing ever held by the court. And it was also the first Supreme Court argument to ever be live streamed. There is no decision yet in USPTO versus Booking, but the issue that the Supreme Court is looking at is whether the addition by an online business of a generic top-level domain like .com to an otherwise generic term, possibly like booking, can create a protectable trademark. So we will be anxiously awaiting that decision by the Supreme Court. I have a few poll questions about this oral argument. If we can pull up the first one. How many questions did Justice Thomas ask in the Booking.com oral argument? Give you a few seconds here. All right, and the correct answer is 4. Great job, everybody. Justice Thomas is known for not asking questions during oral argument, but in this case, he asked 4 questions, which is pretty high. Some guess that the process of asking questions in the telephonic hearing may have been what prompted Justice Thomas to ask questions in this case. So now we have another fun poll question, and there is no right answer. So just let us know what you think. Which Supreme Court justice committed the flush heard round the world during the USPTO versus Booking.com oral argument? All right, so we seem to be a little undecided. I think that's okay, although a few more of you selected Justice Kavanaugh. I don't think we'll ever know who committed the flush heard around the world, but I think it just serves as a good reminder to always meet yourself on conference calls. And so we'll be awaiting the Supreme Court's decision on that.
Thanks, Molly. Thanks for those fun questions. So let's talk next about the ROMAG ruling, which is actually pretty important to us trademark litigation practitioners.
Yes, so ROMAG Fasteners v. Fossil is one of the most important cases that we've seen in trademark law for many years. It drastically changes the amount a plaintiff may be entitled to receive in a trademark infringement case, so it really changes the analysis for both plaintiffs and defendants. To give a little bit of background, ROMAG Fasteners sued Fossil for trademark infringement, among other things, based on Fossil's use of counterfeit fasteners. The jury in that case found that Fossil had acted in callous disregard of ROMAG's rights, but did not find that Fossil had acted willfully. Willful infringement is an important term when determining whether a plaintiff is entitled to disgorgement of profits. And in this case, the district court held that ROMAG was not entitled to disgorgement of Fossil's profits as a remedy because the jury did not find that the trademark infringement was willful. The Court of Appeals affirmed that decision, basing it on Second Circuit law, which requires proof of willfulness. Interestingly, there was a split among the circuits before going to the Supreme Court. And the Supreme Court, in its recent opinion, ruled that there can be no categorical rule that a plaintiff can be entitled to profits only after proving willful infringement. They held that willfulness can be considered in the analysis, but it cannot be an absolute precondition.
Thanks, Molly. This is obviously a really important decision out here in the Ninth Circuit. The rule before the ROMAG ruling was that you had to show willfulness in order to disgorge defendants' lost profits. So this is a fairly big sea change for us. Eric, how do you think the ROMAG decision is going to impact litigation and pre-litigation of trademark infringement cases going forward?
Yeah, well, obviously this decision makes an important remedy, disgorgement of infringers' profits, available in more cases, including those in the Ninth Circuit, as you mentioned, Erica. It's generally simpler to prove infringers' profits than it is to prove lost profits, for example. And now with willfulness no longer a threshold requirement for recovery of disgorgement of infringers' profits, more trademark owners will be able to obtain this remedy than before the ROMAG Fasteners decision came down. This obviously depends on the facts of each case, particularly because the Supreme Court was careful to note that this, we're not throwing out willfulness or state of mind in the analysis. It's still a part of the analysis. It's just not an absolute precondition. So this will likely alter the strategic calculations both for trademark owners and accused infringers. As to trademark owners, they'll likely have more incentive to press forward with litigation in hopes of obtaining an award of infringers' profits. They may have more leverage in settlement negotiations than they did before, as defendants face a greater risk of liability for a sizable disgorgement award. On the other side, parties threatened with trademark litigation will have to carefully consider the risk of a possible disgorgement award, and we'll have to carefully analyze the extent of their knowledge of the asserted mark. This is going to increase the importance of good trademark clearance searches, because parties may now be subject to disgorgement of profits even in situations where they weren't necessarily willful, so those are the primary ways in which we see this affecting litigants.
Yeah, I guess in time will tell how courts interpret that willfulness is an important component, but not a categorical rule. So we'll have to see how the courts end up interpreting the ROMAG decision in moving forward. So Molly, let's talk next about the Lucky Brand v. Marcel Fashion decision.
Sure. This was a unanimous opinion by the Supreme Court, but a very narrow holding. The parties in this case, Lucky Brand and Marcel Fashion, were involved in litigation over a 20-year period, and it involved 3 separate cases, so it's a very long background. And to touch on it at a high level, the parties were engaged in litigation in 2003, where Marcel sued Lucky for trademark infringement based on Lucky's use of the phrase "get lucky," which is a trademark owned and registered by Marcel. The parties entered into a settlement agreement where Lucky agreed not to use the phrase "get lucky," and Marcel agreed to release claims against Lucky's use of its own trademark Lucky. In 2005, Lucky sued Marcel for trademark infringement, and Marcel counterclaimed for infringement of its "get lucky" mark. Marcel, in its motion to dismiss and answer, claimed that Marcel's counterclaims were barred by the settlement agreement, but it didn't actually invoke that defense in the later proceedings. Marcel ended up prevailing on that, and a preliminary injunction or permanent injunction was issued against Lucky. In 2011, the third of 3 separate cases between the parties, Marcel again sued Lucky for continuing to infringe the "get lucky" mark. Lucky argued that Marcel's claims were barred by the settlement agreement, and Lucky argued that this defense was precluded because Marcel could have argued it in the 2005 case, but did not. The Supreme Court ultimately held that because the 2011 action challenged different conduct and raised different claims than what was originally in the 2005 action, could not be precluded from raising this defense. The interesting point about this is that it's a super narrow decision, so we'll have to see how it plays out in other cases. Litigants will want to be sure to use to argue that defense preclusion satisfies the requirements of issue preclusion or claims preclusion. In this case, they did not, because the claims were based on different facts, considering it was continuing infringement that occurred after the 2005 action was resolved. Trademark owners may also want to consider seeking broader injunctions in initial lawsuits or as part of settlement agreements, and to try to assert those prior judgments against repeat infringers, rather than filing new complaints where defendants can rely on previously unasserted defenses.
Thanks, Molly. Not to be overlooked, the Supreme Court also decided a few cases regarding copyright. And Eric, maybe you could take us through those decisions.
Yeah, so the first was Allen v. Cooper, decided in March of 2020. This was a copyright case involving a photographer, Allen, who sued the state of North Carolina for infringement of his copyright in certain photographs that he took of a shipwreck off the coast of North Carolina of the Queen Anne's Revenge, which the infamous Blackbeard captured and used as his flagship. North Carolina said, we are immune from suit under the 11th Amendment because of sovereign immunity under the Constitution. Allen said, but the Copyright Remedy Clarification Act of 1990, which Congress passed, removed sovereign immunity. Well, the Supreme Court disagreed and said, we're going to strike down the Copyright Remedy Clarification Act of 1990 as unconstitutional. Congress, you lacked authority to remove state sovereign immunity for copyright infringement suits. This was a unanimous decision. It was really an extension of a prior decision of the Supreme Court, which had held that similar attempts by Congress to remove sovereign immunity for states for patent infringement suits was likewise unconstitutional. The other case, Georgia versus publicresource.org, this case involved the official code of Georgia annotated. Included with Georgia statutes are certain annotations that are prepared under a work for hire arrangement by a division of LexisNexis under the supervision and authority of a division established by the Georgia legislature called the Georgia Code Revision Commission. The publicresource.org is a nonprofit. They aim to improve public access to government records. They uploaded the entire annotated code to their website, distributed copies. Georgia sued them for copyright infringement, claiming that it owned copyright in the annotations to the official code. And the Supreme Court, in a 5-4 decision, held that the annotations were not eligible for copyright protection because LexisNexis was acting as an extension of the state legislature under a work for hire arrangement in making the annotations. So therefore the annotations were prepared pursuant to the legislature's authority, running right into what's called the government edicts doctrine, which prevents any copyright from being owned in the law, essentially judicial opinions or statutes. No one could be an author of the law is essentially that doctrine, and that applied here to prevent copyright for the annotations.
Thanks so much, Eric. So now let's switch gears a little bit and talk about specifically PTAB proceedings and if there have been any developments there.
Yes, thank you. So in the USPTO, in terms of PTAB and TTAB litigation, the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board, oral hearings and examining attorney interviews had been held remotely via video or telephone since approximately mid-March. Otherwise, things have continued according to normal procedures, in part because depositions, in-person hearings are less common in these proceedings than in district court, for example. Next slide, please. To give you a sense of trends before the Patent Trial and Appeal Board, I'd like to share with you some statistics taken from the PTAB website through April 2020. As you can see from this slide, PTAB filings, which would include inter partes review, post-grant review, and covered business method review, have kept pace so far in 2020, and even experienced an uptick in February of this year. Next slide. However, as you can see from this slide, even as filings have remained steady, the rate at which the PTAB has granted review of these petitions has declined nearly every year since the PTAB began hearing these petitions under the American Invents Act. And this decline actually accelerated from fiscal year 2019 to fiscal year 2020. Next slide, please. So why this acceleration of decline in institution rates? An important decision in this regard is NHK Spring versus Intraplex, which is a presidential PTAB decision handed down in 2018. This decision involved a petition for inter partes review filed against a patent owned by Intraplex relating to a component of a hard drive. The PTAB denied review for several reasons, and important for our purposes. It exercised its discretion to deny review based on, not on the merits of the petition, but rather on the existence of a parallel district court lawsuit between the same parties involving the same patent and involving similar prior art references asserted against the patent. Under those circumstances, the board concluded that proceeding with the IPR would be an inefficient use of its resources given the district court litigation. The PTAB designated this as precedential in May 2019, and since then parties have been using this to their advantage. Patent owners have been using this to their advantage to get out of inter partes review through non-merits reasons and even avoid having to lay out their positions as to the merits. Other PTAB decisions have denied review on similar grounds, citing NHK Spring. The PTAB recently denied inter partes review in a case we're handling on behalf of a patent holder, citing NHK and pointing to co-pending litigation involving the same parties. Next slide. Lastly, I'd like to highlight a couple of decisions that are notable in terms of their relation to PTAB proceedings. Both of these reinforce the general rule originating in the text of the 2011 America Invents Act, which created the inter partes review procedure, that the PTAB's decision whether to institute review of an IPR is not subject to judicial review. The first decision was the Supreme Court's decision in April in Thrive versus Click-to-Call. In this case, the Supreme Court in a 7-2 decision held that the timeliness of an IPR petition is a determination that's not subject to judicial review. And in the second case, the Federal Circuit in a precedential decision in May, citing Thrive and other prior cases by the Supreme Court, including Cuozzo, a 3-judge Federal Circuit panel further extended this rule to bar appeal of institution decisions involving arguments that the petition failed to name all real parties in interest.
Thanks, Eric. So I just want to let everybody know our panelists have been fielding questions in real time, but if you have any questions you'd like us to address at the end, go ahead and use the chat feature and you can send us your questions and we'll try to address those in a little Q&A at the very end. But for now, let's turn to our final topic, which is what is going on outside of the courts, specifically on social media, and what remedies do clients have other than litigation to protect their IP rights?
Yeah, Erica, I'll be happy to start there. So it's no surprise that we've had a dramatic shift to a virtual world over the past few months, and particularly e-commerce has become so important for us to do our shopping, and social media has been everyone's been very participative in being online, and so obviously this is a perfect storm to create lots of opportunity for counterfeiting and other just significant misuse of intellectual property. We'd always seen knockoffs and counterfeits in the luxury goods and apparel fields, but really the more serious things that we've seen lately are the new essentials like pharmaceuticals, medical products, health and safety items, even, things like toilet paper, things, Lysol wipes and things like that. So it's no surprise that some bad actors have seized on this opportunity to do some bad things online, and brand owners have had to be especially watchful of potential misuse of their brands. Even legitimate products have seen some issues. I'm sure a lot of you have seen the 3M lawsuits related to the very essential N95 masks, to where some distributors were selling legitimate N95 masks, but at insane markups, something like 600% up from the original price, and these were going to municipalities, state governments, and hospitals. So 3M really saw a big problem with that and filed some suits to try to stop the misuse of what was essentially tarnishing the 3M name. Some of the suits are in various stages. I know that there was a decision earlier in May to where a preliminary injunction was granted to where the distributor was enjoined from using the 3M name or branding in a way that was causing confusion. So those have been some major issues. We can go to the next slide. And really, this has just caused brand owners to need to adopt fresh perspectives on their intellectual property portfolios. One of the things I do with my clients are to do what we call a brand audit. Take a look at what's registered now and what is registered. Does it really cover, everything that you need, both protecting your brand now and sort of looking into the future? And so if you see some gaps, then it's time to prioritize how you can, file new registrations to really protect you with those gaps, and not necessarily, not just in the United States, but also geographic coverage, because trademark rights are recognized generally on a country-by-country basis. So you may find that there are markets outside of the U.S. that have become really critical places for you to be protecting your intellectual property rights. And so it's important to think about what countries maybe you're lacking coverage, and also just for other enforcement options, as Molly may have time to discuss, there are certain platforms that require you to have a registered trademark in order to enforce your brand. We've seen, the Amazon brand registry is a way to help legitimize certain hosts or vendors on the site, and so having a registration is a requirement there, as well as for some other takedown measures. So we can go to the next slide, please. Yeah, so really in this new virtual world, are your registrations adequately covering you perhaps in new technologies? If you're a content company and you've shifted to providing a lot of your content through various streaming or electronic means, do your registrations cover that? If you filed your Housemark 15, 20 years ago, this new world was not even contemplated. So taking a look at what's covered and any sort of refreshing things that need to be done to bring the brand up into the current environment and beyond, this is a really good time to take a look at that. Also, whether there's opportunities to reach new audiences through licensing or cross-marketing opportunities. Again, the situation has kind of forced us to take a new perspective on how we're protecting our intellectual property and things that we can do as we look towards the future. Next slide. And I think we can advance maybe one more. And Molly, you want to take some of this?
Yes, sorry, I lost my mouse there for a second. Just to talk briefly about a few social media good housekeeping things. It's always good when you have social media to make sure that you have good protection measures in place, such as we can move to the next slide too. Sorry. Such as 2 and 3 factor authentication, and creating and enforcing appropriate corporate policies. In particular, it's important to have your social media accounts registered in your company's name and within and limiting the number of people that have administrative control over your social media accounts in case somebody does leave. And so just kind of checking those things and making sure those are all up to date, and you have as good of protection measures in place as you can for social media is always good, but particularly in a time where more people are online and maybe there's bad actors out there. To move to the next slide. And in terms of just protecting your IP, as always, there's a number of ways that you can do that. You can send cease and desist letters or do takedowns, as Amy noted. But it's always important to make sure that you're considering the possible PR perspectives of your takedown measures. For instance, Netflix did a nice cease and desist letter a few years ago that people actually thought was pretty cool. They asked the people of they sent a cease and desist letters for Stranger Things, asking people to not have a pop-up shop, but they did it in a fun way, and consumers actually thought that was nice and cool. And you always want to be sure that whatever enforcement measures you take don't end up making matters worse. There's something called the Streisand effect, I'm sure you've heard of, where Barbara Streisand complained about a photographer taking pictures of her house and distributing them, and it ended up blowing up. More people wanted to visit her house and see it in person, and it just ended up making it a bigger deal than it ever would have been before. So when you're doing enforcement online, whether takedowns or cease and desist letters, you want to be sure that you're considering how that will affect consumers and what people think.
Thank you, Molly, and thanks everybody else. If we could just go to the last slide, please. So if anybody, I didn't see any further questions come through, but if any of you want to follow up with any of our speakers after the call, here is our information, and we'd love to hear from you if you have further questions. I also want to point out specifically for those of you that want to receive CLE for Kansas, you'll notice there's a CLE code at the bottom of the screen here. I encourage you to jot that down, special requirement for those looking for Kansas CLE, and we will follow up with you directly more on that. I appreciate everybody joining today. If there are no further questions, I guess we can end a couple minutes early. And I appreciate you guys joining us today. Thank you so much.